Erasing $430 billion of debt with a single signature put the United States Constitution under a direct stress test. Student loan debt has reached a scale that threatens the financial stability of an entire generation. To address this, Joe Biden entered office with a 2020 campaign promise to provide immediate relief to millions of individual borrowers. But there was a problem. Under the Constitution, Congress holds the power of the purse, and a gridlocked legislature refused to pass any bill that would authorize the cancellation. To fulfill the promise, the administration chose to bypass the legislative branch. It transformed a standard policy debate into a confrontation over the limits of executive power. The administration relied on the HEROES Act, a post-9/11 law designed to protect the finances of soldiers deployed to war. In 2022, the Department of Education used the fading COVID-19 pandemic as a national emergency to access specialized powers hidden within that military law. By treating the pandemic as a continuing crisis, the administration attempted to cancel debt for 20 million people without a single vote from Congress. This move toward unilateral action changed the strategic landscape. It forced political opponents to develop their own unconventional legal maneuvers to stop a program they could no longer defeat in the legislature. To stop the president in court, opponents had to prove standing. In the American legal system, a party cannot sue unless they can show a direct, concrete injury, usually a loss of money. This was a massive hurdle for the 6 states suing to stop the cancellation. None of them were actually losing money, which technically meant they had no right to be in court. Missouri found a solution by claiming injury on behalf of Mohila, a student loan corporation created by the state. Even though Mohila is a completely separate entity, Missouri claimed its potential losses as its own. The Supreme Court accepted this, granting Missouri special solicitude, allowing the state to sue on behalf of a corporation that didn't want to be involved. By lowering the bar for standing, the court created a path for states to challenge federal policies based on indirect or hypothetical harms. With the door to the courtroom open, Chief Justice John Roberts led a 6-3 majority that officially struck down the debt relief program. Roberts utilized the major questions doctrine. This rule dictates that if an executive agency wants to make a change with massive economic or political significance, they must have clear, specific permission from Congress. The court ruled that the executive branch was hiding an elephant in a mouse hole, arguing that a law intended for soldiers in 2003 could not be stretched to cover a $430 billion domestic program. The decision gave the court a powerful tool to check any presidential action they deemed too broad, regardless of the words in the statute. When the Trump administration took office in 2025, they entered a new environment where executive power rules had been reshaped by the student debt fight. They immediately began rewriting the regulations for public service loan forgiveness directly through the Department of Education. They utilized a new executive loophole, creating rules to block relief for any borrower whose employer was vaguely deemed to have a substantial illegal purpose. This demonstrated the irony of the pendulum swing. The same administrative tactics used to grant relief were now being weaponized to deny it. This political tug-of-war has left millions of borrowers in financial limbo, their futures tied to the outcome of the next court case. The conversation regarding the cost of college has been replaced by a partisan struggle over which branch of government truly runs the country. Presidents continue to bypass a gridlocked Congress by stretching old laws, while courts respond by rewriting the rules of who can sue and what the law means. When every policy is a tactical maneuver and every law is pushed to its breaking point, the system of checks and balances begins to fail. We are watching the American fulcrum being pushed past its limit.